start time, and so the panel has opted to proceed so that we had the opportunity to hear the appellant's argument. And with that, we are recording. We are now live streaming. As I think you're probably familiar, you have 20 minutes to make your argument. We have read the briefing. We've reviewed the record as indicated by our desire to set argument. We have some interesting questions for you. So with that, please proceed. Thank you. May it please the court. William Doyle on behalf of the appellants. I'm here with Brandon Milam of my office as well. I'm happy to make an argument, but I know you have some questions, so let me sort of embark on that, and if you have questions, obviously please proceed with whatever you want to ask. Well, then let's talk a little bit about the, how do you say it, McAfee? McAfee
That's
rule.
where I was going to start. So
great. It does seem to be a little bit of a threshold matter. I guess my initial question is, walk with me through a hypothetical, assuming that we were to say that the Superior Court erred in allowing in the evidence and testimony as to the direct negligence under the McAfee rule, but that evidence was not prejudicial. We presume that the jury followed the instructions that it was given. If that's where we're getting in the end, do we have to decide as a court whether or not the state of Arizona adopts this rule? Wouldn't we ultimately not need to get there because in the end we'd be finding it not prejudicial?
No.
Okay.
The candid answer is no.
Talk to me more about
because that. It is inevitable that it's prejudicial.
Okay.
And here's why. I'm going to give you a variety of reasons, but I'm going to start with what may not be the most obvious reason. The Supreme Court within the last, 18 months has issued the swift transportation opinion, as I'm sure the court is aware. Mm-hmm. And that opinion not only reinforces, but appears to substantially entrench the standard for punitive damages. Granted, it adopts the prior standards from Lithicom, but it's a clear and convincing standard. It's a very high bar. The court has made it clear they want it to be a high bar. The reason it has to be prejudicial, or at least is sufficiently prejudicial to result in a reversal, is because what's going on in this case, and what goes on in many cases where negligent entrustment is alleged, is that the plaintiffs, and I use this term not pejoratively, are backdooring an implied aggravation and punitive claim to get around the strict language of swift transportation. For example, if I use a hypothetical where there is a punitive damage claim alleged that the judge is going to allow, the trial judge is going to allow to go to the jury, or at least hasn't been thrown out yet on directed verdict, then evidence of the driver's past driving record and evidence of the employer's failure to identify the past driving record is relevant to the punitive damage claim. It is not relevant for any other purpose because the company has admitted vicarious liability, the driver has admitted 100% fault. So the only purpose you can bring that other evidence in is for the purpose of aggravating the claim against the defendants. And of course, the proof of that in this particular case is that the jury apportioned 60% of the fault to the company, not to the driver. And if you review the Mahaffey case and review also the Wyoming Law Review article that we, I believe, submitted with our brief, they make it clear that the point of not bringing the information is because all of the fault has already been admitted. There is no reason to apportion fault between the owner of the vehicle.
Well, let me have you pause that. Let's say that I find the Supreme Court of Utah's Ramon B. Nebo School District to be quite persuasive on a couple of points, not least of which is the plaintiff simply has a statutory right in a comparative fault state like Utah and like Arizona to ask for that apportionment. And there are, if not other reasons, there are at a minimum public policy reasons for finding out who is more at fault and what kind of remedial action should be taken in the future. The apportionment of fault is different than damages, right? That's just the apportionment of fault. So at best what we're doing is allowing the plaintiff to dictate, as the court in Utah kind of talked about, the plaintiff's right to dictate, I want to bring alternative theories, I want to litigate them, the factual basis, support them. The plaintiff still has to prove up the damages. And so that's really where the question lies on proof. Why do we need to take away their ability to pursue a comparative fault verdict?
Because the evidence they're trying to bring in to pursue, it's not a comparative fault verdict. For example, in this case, 100% of fault was admitted. There was no basis to apportion fault. And so what the trial court allowed was the plaintiff to put on evidence of additional negligence of the owner, MedStar, under circumstances where MedStar could be held no more at fault than they had already admitted. And so the only purpose, that exposes MedStar to evidence that isn't relevant to the previous admission. It wastes everybody's time, and it creates an environment where the jury is hearing information that in a straight motor vehicle accident, without, even with respondeat superior admitted, would never be admissible. Mr. Ortiz's driving record in this case would never have been admissible in the absence of this claim.
Could a superior court, so let's say we rejected, or let's say we're in Utah, so we're under the Debo case. Could the superior court grant summary judgment on vicarious liability but allow a negligent employment claim to proceed? Does this hinge on the admission or just
It hinges on the admission.
Right.
I mean, certainly the court can, but I'd be up here arguing that it was error to do so. Because once the admission is made, and if we presume that the trial court even entered judgment before we got to trial, the plaintiff moved for summary judgment, et cetera, even if that happens, the fact that there is an admission, there becomes no relevant basis to allow any other information in. There can be no further claim. That's why the cases talk about the claim being superfluous once the admission is made, because the owner can only be liable as a result of the acts of the driver. Right? If Mr. Ortiz doesn't rear-end Mr. Roaf, then it doesn't make any difference whether he's in the course and scope, and it doesn't make any difference whether there's vicarious liability. It is the act of rear-ending Mr. Roaf that creates the liability on the part of those two defendants. And once they admit that, there can't be any other basis to find them at fault. It doesn't matter that there's a comparative negligence statute, because there is nothing to apportion. The only apportionment then that can take place is the 100% that's already been admitted. And so while I appreciate the court's question, I want to keep taking it back to the backdooring in an implied punitive claim, because there's no other reason to bring that information in. And if you review the record, which I know the court has, it's obvious that's what the plaintiff was doing. They were attempting to backdoor a punitive claim by bringing in aggravating circumstances surrounding the hiring of Mr. Ortiz when there was no causal connection in terms of the allegations to that conduct. All right? Because all they did was bring information that was superfluous, and the only purpose for which it could have been brought was to aggravate the jury's circumstance. In
terms of the sort of whether we should, as a state, adopt the McAfee rule, why can't we leave it to the superior court judge to determine on a case-by-case, piece of evidence by piece of evidence basis relevance and prejudice, like we do in other areas?
Well, I think you can, and we objected to it, and that's why we're here. In our opinion, it was error to let it in light of the admission. The error is only magnified by providing a verdict form that allows apportionment between the two defendants, but the true error was letting the information in and allowing the plaintiff to argue that information as an aggravating factor during closing argument.
So the true error was the court denying your motion in limine?
Correct.
Okay.
Correct. Right, because at that point we had admitted fault, we had admitted 100% fault, we had admitted respondeat superior. There was no reason for that information to come in other than, as I've said, on an aggravating basis. Any other questions on, and I do want to point out to the court that there is an Arizona Supreme Court opinion. Now, I'm going to, of course, I want you to mention that it is quite old. It's 1967. It is issued under the restatement, first restatement, before Arizona's adoption of the second restatement, okay? But it predates Briones.
Is that the Lewis case?
Yes, the Lewis case. And the reason we think it's important is because it does give an indication that the Supreme Court is willing to consider and adopt ultimately what turned out to be the McAfee rule. Justice Udall in that Lewis case says the information isn't relevant and it can't come in other than some reason to aggravate the circumstances. And I'd like to point out as to Quiones, I think it is, the only allegation in that case was negligent entrustment, right? And it was a punitive damage allegation. It was before Lithicum. So the idea that Quiones controls the circumstance here, it's completely distinguishable. And frankly, Judge Thomason's reliance on it, even though he had read McAfee, we think is error.
Let's talk on this.
I was just going to say, so why are you arguing for the adoption of the McAfee rule if in fact your true issue is with the denial of the motion in limine?
Because if McAfee had applied, that claim would have been eliminated. There would have been no need to file a motion in limine, right? We would have the directed verdict on that issue would have been granted, and none of the information relating to the Ortiz's driving record would have come into evidence.
And actually, I have a question about kind of the procedural history. So the court denied your motion in limine, I want to say something like a year and a half before trial. And then after day 4 of the trial, at the close of evidence, the court seemed to, on its own volition, raise the issue again. And the parties seemed to respond that I think Mr. Roaf said, oh, well, they should have raised that. And there was just some confusion about whether or not that had been raised. Can you explain what happened there? Because it seemed like everybody was acting like that hadn't already been denied.
I can. The case had been set for trial. We were on the verge of trial a year and 2 months earlier. That's why the motion in limine was filed so early. And then shortly before trial, there was a revelation relating to Mr. Roaf's disability file and disability application in a lawsuit he had filed in Florida, which had never been disclosed because there had been experts that had reviewed his medical condition. And so we moved the court for an opportunity to go do that discovery. The court agreed and then kicked the trial date off. But the court, all the motions had been filed. In fact, I think even the pretrial statement had been filed. The court went ahead and ruled on those motions. So when we get to when the trial actually occurs, no criticism of Judge Thomason. He did not realize that motion had been filed and granted. That's why he suggests in his order relating to the motion for new trial that he's the one who raised that issue. In fact, he was not. We raised it a year and 2 months before. And the purpose for which we raised it was it's not relevant because we've admitted 100% fault. Right? And so, again, it's the same concept that I've mentioned earlier. So it was properly raised, and when the plaintiff tried to bring that evidence in, we objected to it during the testimony.
So if you admitted 100% fault, and so you obviously that comes 100% liability comes with that, I'm trying to figure out where the prejudice is here. The jury award, Mr. Roaf requested $17 million in compensatory damages, is my understanding. The jury awarded him something like $4.625. And there were multiple experts that testified to amounts that would support that jury award. So I know you say this evidence came in and it was, purely to punish MedStar and aggravated. But where, other than kind of speculation, where is that in the record? Well,
I can tell you it is. I can break the damages down and demonstrate to you. This sort of also rolls into the the expert's testimony relating to future medical expenses for which there was no foundation. But
Now let's assume we agree with you there. Can you speak to the other expert? Because there was other expert testimony.
yes, but none that suggested, in terms of damages, none that suggested any future medical care other than $324,000. Right? Remember that the plaintiff's expert on future medical care was only allowed to say he relied on Dr. DeGroot, but not what Dr. DeGroot told him. And you notice he gave the throwaway line of a physician's opinion or something like that, which the court just dismissed as throwaway, essentially. But of course, he was trying to create some authority for what he was saying. When DeGroot testified, he didn't lay any foundation for that future medical care. So I now have $4.5 million in future medical care when the only foundation for any claim of that is $324,000. All right. Granted, the plaintiff may have asked for $17 million in their closing argument, but anybody can ask for any amount they want. But if I look at the numbers, the plaintiff has, let's give him the benefit of the doubt. He has $3 million in lost wages. He's allowed to make a claim for $4.5 million in future medical care. He's got $500,000 in past medical expenses. And he says he's going to have a lifetime of pain and suffering. If I add those numbers up, that's about $10 million, right? And the jury ended up only giving them approximately half of that. Now, you may say, well, of course, then that suggests none of that information was prejudicial. But from the defense perspective, if the future care number doesn't ever come in and there's no basis for it, suddenly the amount of money that the jury is considering, special damages that the jury is considering, goes from $10 million to only $6, really $6.5, all right? And so if the jury is assessing the claim that it really only has a 50% value of where the damages were that were admitted, well, suddenly that creates a verdict that's in the $3 million range. Well, that's prejudicial to the defendants, right? And when I take into account that the plaintiff tried to aggravate the circumstances by talking about the conscience of the community, tried to aggravate the circumstances like by sending a message and those types of arguments, well, and then I look at the fact that the jury apportioned the fault 60% to MedStar and only 40% to the person who actually caused the accident, that tells me the jury listened to the aggravating argument, all right, and tells me that that allowing the information about the driving record in fact, had an impact on them. Now, I can't know for sure, but we have to presume that they considered the evidence that was presented to them. And so when I mix all that together, I go from a $4.65 million verdict to a verdict probably less than $3 million. Now, granted, that's still a lot of money for the
plaintiff. At this point, aren't we kind of in the realm of just sort of building speculation upon speculation for an appellate court when what we do have is that the jury heard testimony that supports more than the $4.65 million awarded?
Absolutely, Your Honor, absolutely. And that's the point. They considered evidence, which you are to presume they considered, right? They heard and considered that should not have come into evidence because there was no foundation for it. Where does this $4.5 million come from? The jury was not given any information about where it comes from, what physician.
Did you request a special verdict form or special interrogatories to get at that?
No, I did not. And because, well, for a variety of reasons, but I did not because I had already.
Where I was going with my question was then how can we determine with sufficient, from our vantage point as an appellate court looking at, abuse of discretion standards here, how can we determine that something was aggravated when what the jury ultimately awarded was less than the testimony that they heard? Because
A, the information came in without foundation, was not admissible under the rules, and B, because of the apportionment of fault to MedStar. That's how this court reaches a conclusion that allowing that information into evidence was prejudicial to these defendants. whether it's on a de novo standard with McHathy or whether it's on abuse of discretion standard relating to Orlowski's testimony. Anything else? I mean, I have a minute, I can tell you more, but,
Do you have more questions?
all right, thank you.
Thank you, counsel.
Now I'd like to give Mr. Abney's part. Oh, sorry.
I will just again note for the record that we're almost an hour past our original start date, and we haven't heard from or seen counsel for appellee. We will consider the matter for appellee submitted on the briefing that was previously provided and take into account the arguments made by appellant here today. And with that, court stands adjourned.
Thank you.
Thank you.